Well, it's all about religious freedom here, Betty, which, as you can hear from the sounds around me, it's a very, very controversial issue. It's the last day of decisions here at the court. It's also the loudest day of decisions that we've seen so far. It's a small provision of the Affordable Care Act, but again, hugely controversial, that requires employers to cover contraception as part of minimum coverage. So you've got these two companies, both Hobby Lobby and Conestoga Wood, one out of Oklahoma, one out of Pennsylvania. And the owners of these companies say that two forms of contraception they find that they morally disagree with, that they equivalent with abortion. So they're against this. They want to be able to opt out of the law under their rights of religious freedom under this 1993 law that allowed individuals religious freedom rights to opt out of laws. They want that to be extended to businesses. So very controversial question. Justices seem pretty divided during the arguments. And Betty, worth pointing out, this is the first time that the court has looked at the Affordable Care Act since 2012. Betty?
Clearly impassioned protesters behind you. Megan, there's another big case today that could have real impact on public unions. Tell us more about that.
Yeah, it's Harris versus Quinn. So this is a case about home health care workers in Illinois. They were deemed to be public workers, and that meant that the unions could start taking money out of their paychecks. They say that's against their First Amendment rights. So if the court makes a broad decision in this case, it could have tremendous impact for public unions, for the SEIU, for AFSCME. And they're fighting against a big right-to-work group with a lot of big conservative deep pocket donors. So it'll be very interesting to see what happens in this case. Again, if it's a broad decision, it could impact about half the country.